Hello everyone. I hope everyone is keeping safe and doing well. So last week we discussed about the basic meaning of due diligence and what does a due diligence exercise entail. So in this episode and the coming episode, we'll be discussing in detail about a due diligence exercise. How does a due diligence report look like? So now starting with the due diligence report itself, before going into any details about the various chapters of a due diligence report, I would want to in brief discuss about the various sections of a due diligence report and what are the different kinds of due diligence reports which are prepared. So last week we did discuss that a due diligence can be initiated at the behest of the investor, it can even be initiated at the behest of the seller itself, and in such cases the due diligence report prepared is called a vendor due diligence report. Keeping this aside, even if the due diligence report is initiated on the behest of the investor or the seller, a due diligence report which is prepared can either be a red flag issues based due diligence report, or it can be a full-fledged due diligence report. Now coming to the difference between these two kind of reports, the key difference being is that in a full-fledged due diligence report, all sort of information which a lawyer analyzes while reviewing the documents, all the information is summarized in one form or the other and presented in the report. Like, to give a very simple example, a company might be entering into tons of agreement for its day-to-day business operations, or it would be a party to many material contracts which are key to its business operations. So in case, like, now I'll take I've given this example, now I'll try to differentiate that how would a report or how would a material contracts chapter look like in a detailed due diligence report, a full-fledged due diligence report, as opposed to a issues-based due diligence report. Now, if you are reviewing certain contract and if you come across any key term which you feel as the counsel for the investor, if you feel that such a clause should be brought to the notice of the investor, like for example there's a consent requirement in any specific clause, or let's say you feel that that contract has expired, so you would naturally want to highlight this key term or this key essential with respect to that contract to your client. So if you are preparing a issues based due diligence report, then what you would do is that you would restrict your findings of the report or what you are stating in the report to only this key issue with respect to this particular contract. You will not summarize the entire contract, as opposed to situation wherein you are doing or working on a full-fledged due diligence report. So if you're doing a full-fledged due diligence report, then what you would do is that you would summarize this contract. And when I mean summarize, that you will highlight the key terms of that contract, and like for example, which will include the name of the parties, the term, if there is any specific lock-in, exclusivity, assignment, consent requirement, all this you will, and there could be other onerous clauses which you would want to highlight to your client, as opposed to a red flag diligence report wherein you would only restrict your report or the chapter to the issues or only those specific findings which you feel are material to the transaction at hand. One small point which I would want to make here is that even before you start diligencing the documents, or I would say even before you start laying down your analysis post review of the diligence documents in form of a report, it's very important to get clarity on the expectations of your client. And by expectations, what I mean is that there should be no gap in the kind of format in which your DD report is expected to be by your client. So for that, you should, even before putting down your analysis in form of a report, you should even run past the DD template which you will be using your client. So what I mean is that you don't have to just send an old DD report which you had prepared for some old transaction to the client. Don't do that. what you should be expected, what is expected from you and what is practical is to just prepare a DD template wherein you can take any old DD report and remove the basic information or whatever document, whatever issues which you had analyzed or whatever information was there, you just totally remove it. Only let the heading of the chapters and the heading of the issues table stay, at least present the scope of the DD, and then get it approved by your client. So it would remove any kind of confusion which could be in the mind of the client, or it would ensure that there is no lack of communication in the expectations of your client with respect to the kind of report which the client is expecting. Now coming to the various sections of a report, the first section of any DD report would be the introduction and scope. Now this introduction and scope also becomes very important. The reason being is that number one, the introduction and scope lays down the basic information about the target entity or the entities. Number two, it lays down the scope of the due diligence. Now why laying down the scope is important? The reason being is that usually any investor or any party which is relying on the due diligence report, that investor doesn't solely rely on the due diligence report for the purposes of that particular transaction. If the transaction is of a commercial nature and it's a complex transaction, the investor or the concerned party may even involve accountants and tax advisors in undertaking tax due diligence, okay, or financial due diligence. So from that perspective, it is always necessary to at least lay down your scope and the exclusions in your report. So scope would cover whatever you are covering as part of your report, because there could be a situation wherein your client has specifically instructed you not to, let's say, work on a one particular chapter. Like for example, the client knows beforehand that the target company doesn't have any real estate property, it doesn't have any, it hasn't taken any property on lease, or there is no such arrangement, or for that matter, the client doesn't want you to delve into details of the real estate properties of the concerned target entity, or there could be a situation wherein the client only wants you to focus on specific aspects of the company. Like let's say the client wants you to only focus on corporate chapter, material contract chapter, and let's say consents chapter. And some chapters it's okay to, like, basically maybe the client is confident enough, it doesn't want those documents to be diligenced. So in that case, your scope would clearly stipulate that, look, these are the chapters which we have drafted, and our the diligence, our legal diligence is restricted to processing and analysis of only these information. Also, like let's say if it's a it's a red flag diligence report. Like a few minutes back I discussed the difference between a full-fledged report and a red flag report. Then you should clearly state that this is a red flag issues only report, and it doesn't have summary of all the information which we have processed. At the same time, it's very important to even lay down the exclusions in a due diligence report. I would just give few examples of exclusions just for clarity purpose. Like for example, if you are not carrying out any independent search on the portal of Ministry of Corporate Affairs for form filings made by the company with the ROC, and if you are solely relying on the form filings provided by the target company, and your scope of review is restricted to review of only such form filings, then a line to that effect should be ideally included in the introduction section of your due diligence report, stating that for the purposes of review, you have not done any independent search on the portal of Ministry of Corporate Affairs. Similarly, for litigation, a specific line can be added in the introduction section of the DD report, mentioning that for the purposes of the litigation chapter, you haven't done any physical search with respect to litigation pending against the company. Similarly, for IP also you can write a line to that effect. Similarly, for example, if your client has instructed you not to specifically look at any specific legislation for compliance when it comes to the HR chapter, because a lot of times client may not be bothered about checking compliance by a company with respect to labor laws of a specific state, wherein they're not concerned basically about the state specific legislations, and they are more concerned about compliance by a company with respect to the central key labor law legislation, EPF, ESI, gratuity, etc. So in that case, your intro part should clearly reflect that. So another very two small examples, which points which I would want to add here, is that there are two concepts. One is the cutoff date, and one is the look back period. So a look back period basically means that your diligence is restricted to the documents provided by the company which pertain to only those specific period. If let's say if the look back period is 3 years, so if a document pertains to, let's say, a period prior to those 3 years, you won't review. But for example, if it's a key document, like if it is a charter document of a company, or if it's a shareholders agreement which is still in force, or example, if it's a material contract which has not expired, which is still into effect, then the look back period will not apply to such documentation, and you would still go ahead and review such documentation for the purposes of your due diligence. Then the cutoff date basically means that, let's say if the due diligence report is dated as of today, even then there could be a situation that while you are contemplating to sort of collate all the information together, and if you are working on a very strict deadline, and if you intend to send the DD report out in a day, and during that day itself again there is a document dump from the target company, then ideally it will be impossible for you to again review those documents and then include it. Then, so just to cater to such contingencies, what you write in your introduction chapter, you include a line to that effect that the review of information is limited to the information provided as of XYZ date. So let's say if I'm if a large chunk of document is uploaded right before I'm about to send the report, or let's say 4 hours prior to when I intend to send it, and if I'm not in a position to document those information and process and analyze those information for the purposes of my DD report, then I would be safe, because I have already added a line to that effect that our report or whatever we have included in the report is as of a particular date, as of the information provided by the company as of one particular date. And even though that date and the date of the issue of report, there could be a, let's say, a 1 day gap. So from that perspective, including a cutoff date becomes very important. So we have in the last episode discussed about what is due diligence, what is the meaning of due diligence. Then in this episode we have discussed what are different kinds of due diligence reports. Then we have discussed what is the importance of having an introduction chapter, and what should ideally go in an introduction chapter, and why should we have exclusions and limitations to a due diligence report and review. In the next episode we would be focusing more on the various chapters in a due diligence report, and the various kind of information which we have to review in each chapter, and how to go about it, and how should a fresher take up this challenging exercise right after law school. Thank you.